Welcome back. Over the weekend, Max Verstappen won the first ever Las Vegas Grand Prix, but the event is also at the center of a lawsuit now. A group of Formula One fans filed the class action lawsuit after being forced to leave the venue on the opening night of racing after a driver damaged his vehicle, causing a 2.5-hour delay for the second session.
In a statement, the Las Vegas Grand Prix responded to the lawsuit saying, quote, "Our focus is on ensuring that our fans have an entertaining experience in a safe and secure environment, which is always our top priority."
NBC News legal analyst Danny Cevallos is here with more. Hi, Danny. Always good to see you. So walk us through this class action lawsuit and what it is that these people would need to prove in order to win this case.
The theory behind this lawsuit is essentially that by negligently maintaining the track, the defendants somehow caused these damages to ticket holders who paid for a show and they didn't get a show. The second, about what they need to show to win, they basically need to climb Mount Everest. This is not a case that I would invest in. I'm a civil litigator, and when you take on cases like this, they really are more like an investment. Are they worth you putting in your money on the front end as a lawyer to try and get the benefit of a judgment or a settlement later on? And there are many problems I see with this from the outset. Number one, even if negligent, some things happen during a race, and you may need to shut down a race for all kinds of, same thing will happen at a football game, all kinds of things can happen. Number two, we haven't seen the ticket. I promise you, the ticket is chock full of shrink wrap, click wrap, whatever wrap, all the things that you sign off on when you buy a ticket. And all a ticket does is give you a limited license to be somewhere. You can be kicked out. You can be asked to leave. You don't own that seat. You are only there at the pleasure of the person who owns the seat. And then even the damages themselves. Let's say even you win this case and you take it to a jury. What's a jury going to give each ticket holder for damages? Oh, you were traumatized because you didn't get to see people drive around in a circle? I don't think so.
Yeah. I mean, delays and cancellations happen all the time for a variety of reasons, as you mentioned. So how rare is it to see something like this to try and pursue legal action?
Well, here's what I think. I think probably this law firm sees that there's some possibility, and I'm guessing there might be some consumer protection section of the local law that they think entitles them to remedy or relief. The thing is, sometimes you find with class action firms, these are firms that are really more like investment bankers. They're not like traditional lawyers. They look for issues in the law that they think are worth investing in and taking a chance at. So it may be something that I'm not seeing. There may be, and I'm betting if there is, it's a consumer protection law issue that allows usually for some kind of treble damages, triple automatic damages. You see that a lot in consumer protection. You'll see class action firms target those laws and violations of those laws. But without something like that, this is not that appetizing of a lawsuit.
What's next? What should we watch for?
In civil cases, the first filing of the complaint is really the very exciting part. After that, it gets very boring for a long time because the parties enter into what's called discovery. They do depositions, they exchange information about each other, and unlike a criminal case where you may have hearings along the way, the next fireworks usually aren't until the civil trial. And I got to tell you something, 9 out of 10 cases in civil litigation end in a settlement. They don't go to trial. Civil litigators on the whole are not in court nearly as much as criminal defense attorneys and prosecutors.
Could that be the goal here, trying to get a settlement, perhaps?
Yes, and that's why for a lot of corporate defendants, this kind of defense is more about a business decision. Do you offer what's called nuisance value to the plaintiffs? Do you say, well, here's what it'll cost us to go to trial, and then in theory we could lose a trial. You figure out what that risk is worth to you in dollar amounts, and you offer that to the plaintiff. But other defendants, corporate defendants, take a different approach. They say, you know what, if we do that, we're going to send a message to all the sharks out there, like me. So instead, we're going to fight no matter what, and we're going to take this to trial. And that's what everybody says, but I'll let you know a little secret, Joe. Plaintiffs, defendants all say, we are going to trial. We think we can win. Everybody settles.
All right, Danny Cevallos, thank you so much.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.